Good evening to the students of the International Human Rights Law and read what I posted on the screen. Anyone can unmute and read what I posted on the screen. Yes? Anyone? Yeah, again I will post it so that you could know it. What are the 7 main international human rights? Human rights protected by the International Covenant on Civil and Political Rights, that is ICCPR within parentheses, include the right to vote, the right to freedom of association, the right to fair trial, the right to privacy, and the right to freedom of religion. So these are the 7 main international human rights are there, compiled by the Professor Dr. Mohammed Saheb Hussain. Now let us see what are the 3 important features of human rights. I repeat, what are the 3 important features of human rights? And here you could see the 3 of them, features of human rights. Number 1, human rights are inalienable, i.e., that is, IDST equivalent English is, that is, they cannot be taken away from an individual or a group of individuals except in specific situations and according to the due process. So certain situations or the context only, and that to be following the due process law or the system, then only it can be alienated. If not, they are inalienable. For example, the right to liberty may have to be restricted if an individual is found to be guilty of a crime by a court of law. So if a person is committed a crime, at that instance he will be arrested and sent to the prison. If it is a cognizable offense, yes, bail will not be given. If it is a non-cognizable offense, yes, the bail will be awarded by the respective competent court. Number 2, human rights are interdependent and indivisible. That means they are dependent in each other and we cannot separate them, and they are interwoven and indivisible. You cannot divide it. Without having the means to exercise their civil and political rights, people can assert their economic, social, and cultural rights. Similarly, without means of livelihood and a wrong and a working society, people cannot exercise their civil or political rights. This fact has been confirmed by the Vienna Declaration and Program of Action at the World Conference on Human Rights in 1993. The second point elucidate or explains they are interwoven, interdependent, and they are not divisible. And having the means to exercise that they are the civil and political rights are there, and people definitely will assert their economic and social and cultural rights. The culture should be protected, and the social norms should be maintained, and the economic security would be given to them, and they do have the political right to vote, and the civil right that nobody should have to torture him or her without any legal justification. So this fact has been confirmed by Vienna Declaration and a program action at the World Conference on Human Rights 1993. The third one is human rights are equal and non-discriminatory. That means everybody is equal under the eye of the law, and that is the human rights. And it is non-discriminatory. For white, one human right. For black, another human right. For child, one human right. And the woman, another human right. No. All human rights will be equal, irrespective of the caste, creed, religion, skin, color, and culture, skin, dialect, language, place. We can count all of them. They are all equal, irrespective of the, just now I narrated the things. All human beings are equally entitled to them without any type of discrimination. Child also having the same human rights, and the women, and the old age people, even a eunuch, a third gender is also having the same rights without any type of discrimination. It prohibits discrimination on the basis of sex, male, female, third gender, boy, girl, old age, senile, no. Whatever the race would be there, and whatever the religion is there, and whatever the ethnicity of a person would be there, and whatever the color of a person would be there, whatever would be the caste of the person or community and the economic status of a person. Poor or rich, middle class, everybody will be given the same equal treatment under the human rights. This is based on the principle that all human beings are born free. I repeat, this is based on the principle that all human beings are born free and equal in dignity and rights. They are equal in the dignity and rights because everyone born free. So these are the three important features of the human rights. Now I can show you certain thing. Why I have taken this question is, here I am giving the answer for that one. On the internal test question, IHRL and SLW 722, and there I put this question 1, that is discuss in nutshell what is the international human rights law. Sir, already we submitted. No sir, why this question? If you know it, what is wrong, it may appear in the exam also. Or if you are, any person will ask you, because you have taken the specialization international human rights law, actually what it says. At that instance, you are not supposed to keep your zero face, a withered face, a round face, a pale face, and hence I am dealing this thing. So now let us see how the human rights will make it out. I will show you the one of the video. And here I am sharing now. So one of the video that I would like to show you and how it would work. Yes, here I could make it out here, share, okay, share. Then it has gone somewhere. Let me see it again. Okay. And this one first I want to share with you. Then we'll go one after another. Yes. Just a minute. Where it is gone. Okay. Right. I say share. Yeah. Then you have to unmute it. Where is unmute? We had, otherwise we could not hear the sound. You have to unmute it, then only you could hear the sound. Let me see where it is gone. Share. Oh, that is, it's coming. Yeah, I'm just a minute because I'm trying to make it out. When you share, you should have to unmute it, otherwise it cannot lock meeting in the connect and switch audio. No, this is not. And I will break sessions. No. Then share. Where is the automatically optimized share computer audio? Show me in the front of presentation. Settings. I don't think that you are hearing now or not. If you are not hearing, you tell me.
International human rights law is broadly a subdivision.
Are you hearing?
Law. In public international law, there has recently been discussion of the fragmentation of international.
Just a minute. There is some technical problem I am facing, because unless until you will not make the share, it will not come. That is more important factors. Yeah, yes. Show in front of my presentation. Share the computer audio. Let me check it. What it. Share content. Let me check it somewhere. When you make it share, there appears the speaker. I could not see the speaker here. Changing sharing preference. Automatically activate sharing, layout, notification, appearance, keyboard, accessibility. No, this is not. Window, file, whiteboard. File, no. Whiteboard, Windows. I could see the. Let me check whether you are hearing me or not, so that we can make it out. Okay, let me say share. A recording is in progress. Yes, mute, no. And here share option, share multimedia, share my meeting window, share content. Share computer audio. Let me see that there it is. I think it will come now.
Human rights law is broadly a subdivision of public international law. In public international law, there has recently been discussion of the fragmentation of international law into various specialisms, such as international human rights law, international environmental law, international humanitarian law, and the international law on the use of force. These labels do not refer to a completely separate area of law. Each of these specialisms is part of public international law as a system. Human rights law is not just international, it is part of domestic law as well. Human rights law is thus not a straightforward term, but one that has one meaning for academic study and a slightly different meaning in practice. In practice, the term may be a blend of general international law, a specific treaty, the relationship between international law and domestic law in that country, and the provisions of domestic law relating to the issue at hand. We should know a brief history of international law. Breaking down of the term international means law between the nations. The entities or states, of course, had to interact with other states, be it for trade or conflict, and thus some basic rules had to be established. States often came in conflict with each other, and rules were required to regulate behavior and conduct. Whatever states agreed between themselves was what became international law. Modern international law stems from the consequences of European history and associated political developments. Central to its development is the Treaty of Westphalia 1648, also known as Peace of Westphalia. This is one of a series of treaties agreed at the end of the religious wars in Europe, and it created a network of sovereign states with formal equal standing. International law in this form was born out of a need for states to cooperate with each other. Globalization, as we now experience it, has led to a proliferation of rules that are the product of international law. International law, in its classic European form, is a reflection of the culture and values of the European states. The state system we now have is based on the European model of statehood, as it is European powers that colonized all of the globe. Post-colonial states have emerged from their colonial experience, replicating the European model of statehood. International law has also slowly started to recognize participants that went beyond states. The number of states has increased exponentially since the latter half of the 10th century. This can be seen in the membership of the United Nations. The end of the Cold War in 1989 to 90 has led some new issues and tensions arising in geopolitics. For example, events in Syria since 2011 highlight many differing tensions between Russian interests and other states. The presence of militant forms of Islamic extremism, tension between rival Muslim states, and issues concerning the use of force all coincide. International law is currently undergoing a period of change, but it is worth bearing in mind that normative change in international law occurs due to the existence of crisis. Now we should take a look at what is international law. To understand what international human rights law is, it is important to understand international law. International law is a horizontal legal system with states and very few other legal persons as the participants. States are all formally and legally equal, even though there is enormous disparity in their power, influence, and wealth. This is in contrast with domestic legal systems, which are vertical, and states exist in a vertically superior position to individuals in their internal legal relationship. International law is primarily but not entirely consensual in nature. The issue of consent means that the manner in which the law is enforced will also differ from that in a domestic legal system. In domestic legal systems, we have legal forces like the police for the enforcement of laws and to uphold the law, and courts to enforce the law by punishing those who transgress it. This only applies to domestic criminal law. A better analogy that relates with international law is contract or tort, where there are courts but nothing like an international police force. The International Court of Justice, based at The Hague, does act as a world court of sorts, but it is not a compulsory court as such. The court was originally established in the aftermath of the First World War, and in its current incarnation, it has been established by the Charter of the UN, with the Statute of the Court an integral part of the Charter. The UN Charter states that the ICJ is the principal judicial organ of the UN. Article 36 of the statute gives jurisdiction to the court to decide disputes of a legal nature submitted to it by states. The ICJ can also deliver advisory opinions when requested by certain organs of the United Nations, primarily the General Assembly and the Security Council. The jurisdiction of the court is based on consent. A state cannot be taken to the ICJ against its wishes. It must have agreed with regard to the issue at hand to the ICJ having jurisdiction over it at some point or other and in some form or other. If a judgment made by the ICJ is not acceptable to a state, there is very little that can be done to compel the state to comply with the judgment. Under Article 94 of the Charter, the Security Council can decide on appropriate measures to give effect to ICJ judgments. The problem becomes difficult to fix if the state is a permanent member of the Security Council with a veto power, or a close ally of such a state. The more influential the state, the harder it becomes to get them to comply. Although, under Article 59 of the ICJ statute, the judgments given by the court are legally binding. Now let's take a look at Universal Declaration of Human Rights 1948. In the final session of Grand Assembly of the United Nations, the chair of the Assembly and representative of the United States, Eleanor Roosevelt, stated, "The Declaration might well become the international Magna Carta of all mankind." The outline of the Declaration should be mentioned. Article 1 articulates the underlying principles of the Declaration that all human beings are born free and equal in dignity and rights. Article 2 puts forward two basic principles, equality and non-discrimination. Article 3 has been described as the first cornerstone of the Declaration, as it states the right to life, liberty, and security of persons. Article 22 has been called the second cornerstone of the Declaration. This article can be read as introduction to Article 23 to 27, which enumerate social and cultural rights. Article 28 to 30 stress that duties complement rights. The legal value of the Declaration must be considered. At the time the Declaration was adopted in 1948, the consensus among those drafting it and adopting it was that it was not meant to be legally binding. It was not drafted as a treaty. Indeed, it was adopted as a declaration, as there was no agreement as to if it should be legally binding. This is why what became the 1966 Covenants were adopted as treaties, and it took 20 years of negotiation and compromise to reach legal agreement on the principles and rights set out in the 1948 Declaration. It can be argued that the Declaration outlined binding rules of customary law. The Declaration was adopted by 48 states, but 8 states abstained from voting for it. The states that adopted the Declaration were hardly representative of the global community. And the opening statement, "All human beings are born free and equal and dignity and rights," was hardly credible when supported by numerous European colonial powers and the USA, which still had deeply segregated communities and systematically discriminated against populations who were primarily African American. The provisions of the UDHR were not customary law at the time they were adopted. The prohibition on torture and slavery are good examples of laws that are customary now. However, it does not have all the customary laws in it, for example, the right to self-determination. Thus, the UDHR has been of significant importance in the crystallization of customary international law for some human rights, but still not all. Now we should look at the remedies for breaches of human rights. Some human rights treaties stipulate that contracting states provide a remedy under domestic law for any breaches of the substantive rights entailed therein. This may be due to any enforcement mechanisms that may be established by the treaty itself. However, not all treaties require domestic remedies, nor do they set up an enforcement mechanism. The 1951 Geneva Convention on the Rights of Refugees, a major treaty related to human rights matters, is a good example of a treaty that neither establishes an enforcement mechanism nor requires states to provide remedies. However, every recent major global human rights treaty adopted does have an enforcement body. Article 13 of the European Convention on Human Rights states that everyone whose rights and freedoms sets forth in this convention are violated shall have an effective remedy before a national authority, notwithstanding that the violation has been committed by persons acting in an official capacity.
Yes, that is the which I want to share with you. I believe that Doma, did you hear the video? Because you are not my student, but still you joined, I allowed you to hear my lecture. You unmute and tell me, did you hear the video in proper way? Yes? You can unmute and give me the answer. That is one video that I would like to share with you. So there are another videos also there where I would like to share with you, but only one thing is whether you are hearing me or not, that is more important factor to me. So now this video that I can close it. Yes. And the second one I would like to play, but I want to get the clarification from you whether you could hear the, yeah, this is the second. Show me in front of a presentation. Show me in front of presentation. Okay. Now let us see that whether you could hear it or not. Now we'll make it out.
We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. This is an excerpt of the U.S. Declaration of Independence. And the United States goes on with its Constitution, which gets ratified in 1789, to articulate a Bill of Rights. And many will point to the Enlightenment as the inspiration for these ideas. Thomas Jefferson, who wrote the Declaration of Independence, cited figures like Locke as some of mankind's best thinkers. So at this early date, nations were at least writing these types of words into their declarations of independence, into their constitutions. But despite that, the 20th century is one of the bloodiest centuries in human history. You have World War I, where roughly 17 million people die. In World War II, 50 to 80 million people die, some directly because of the conflict, but many because of lack of access to food and famine. The Chinese are particularly hit. Over 15 million died during the Japanese occupation of China. This idea of genocide comes about. First with the Armenian Genocide in the declining Ottoman Empire, where over 1 million people are believed to have been killed. And then in World War II, You have the Holocaust, where 6 to 11 million people were killed, roughly 2/3 of the Jewish population in Europe, and many others. The Russian Empire and eventually the Soviet Union gets especially hit hard in the first half of the 20th century. In World War I alone, 3 million Russians died. Shortly after the war, you have a significant Russian famine that kills 5 million people. Then in the early 30s, you have the Soviet famine, 5 to 7 million people. This is believed to have occurred because of Stalin's attempts to make agriculture collectivized. In the late 30s, you have Stalin's purge, where he goes after political opponents, and it's believed that he killed as many as 3 million people. These things were so shocking to the planet that they made attempts to prevent them in the future. In 1920, out of the trauma of World War I, the League of Nations was founded. It was an attempt to prevent things like this in the future, for nations to talk to each other and to coordinate so they don't go to war, especially at the scale seen in World War I. But clearly that was unsuccessful, and we have World War II where even more people die, after which the slightly stronger United Nations gets founded, once again with the charter of fostering dialogue between nations so that we can prevent these types of trauma for the planet. Early on in the newly founded UN agenda was this idea of revisiting the ideas of the Enlightenment, this idea of human rights, and trying to codify them in international law. In 1948, you have the Universal Declaration of Human Rights that's drafted by the United Nations. And it was an attempt to make a universal declaration of these rights that all humans on the planet have access to. I'm going to give excerpts of it, and keep a lookout for things that feel awfully close to ideas in the United States Declaration of Independence, the U.S. Constitution, or ideas from the Enlightenment. This is part of the preamble, whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind. Remember, World War II just happened. And the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want, as has been proclaimed as the highest aspiration of the common people. Now, therefore, the General Assembly proclaims this universal Declaration of Human Rights as a common standard of achievement for all peoples and all nations. You might be thinking, why do they even have to write this? Well, think about it. Things like the constitutions of various countries, especially the United States, these only applied to those countries. But now there was an attempt to write down, to codify something that would apply to all human beings, to the entire planet. And here's just some of the 30 articles to that declaration, to that Universal Declaration of Human Rights. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. This really feels similar to some of the ideas of Locke in the Enlightenment that we talk about in other videos. Everyone is entitled to all the rights and freedoms set forth in this declaration, without distinction of any kind, such as race, color, sex, language, religion, political, or other opinion, national or social origin, property, birth, or other status. So this is interesting, because even though I start this video with the United States Declaration of Independence and a discussion of the Constitution, slavery in the United States would last for another 80 plus years after the Declaration of Independence was written. Women didn't even have the right to vote until the early 20th century. So beyond this being a universal declaration for the entire planet, the attempt is also to make it clear that it needs to apply to everyone. Everyone has the right to life, liberty, and security of person. No one shall be held in slavery or servitude. No one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. Everyone charged with a penal offense has the right to be presumed innocent until proved guilty. Once again, ideas that seem very similar to what we see in constitutions like that of the United States. Everyone has the right to freedom of thought, conscience, and religion. Everyone has the right to freedom of opinion and expression, very similar to the First Amendment in the U.S. Constitution. Everyone has the right to freedom of peaceful assembly and association. No one may be compelled to belong to an association. And Article 21 is especially interesting. Everyone has the right to take part in the government of his country directly or through freely chosen representatives. Everyone has the right of equal access to public service in his country. The will of the people shall be the basis of the authority of government. So this is a big statement. It's taking a stand, saying that everyone on the planet should be able to live in a democracy and participate in a democracy. The commission that drafted this declaration was chaired by Eleanor Roosevelt, wife of Franklin Roosevelt. This is a map of who voted for this declaration, and these are the countries in green. Who abstained, they just decided not to vote for the declaration. Those are the countries in orange. And then you have a few that voted against it. In gray are the countries that weren't part of the United Nations at the time. An interesting question, looking at this map, is to think about why certain countries were willing to vote for it and why other countries decided to abstain at the time. These articles are talking about people having the right to participate in a democracy, the right to be equal, that all people are equal. And in many of these countries, people did not have equal rights. You had severe discrimination in places like South Africa. In many of these countries, you did not have a democracy. But there's a broader question here. It's nice to be able to write these fairly idealistic ideas, but to what degree does it have an effect? And to what degree can it actually be enforced? You might cite things like the American Civil Rights Movement, which did echo some of these ideas that were made in the Universal Declaration of Human Rights. Maybe they helped the Civil Rights Movement, or maybe the Civil Rights Movement would have happened regardless of what the UN. But at the same time, you have ideas like apartheid. You had racism and discrimination in South Africa from the beginning of colonial rule, but it was actually at the exact same time as this declaration that the official policy of apartheid, of government-sanctioned discrimination, of government-sanctioned segregation, preventing racial mingling, came into effect and lasted all the way until 1991. And so one could make an argument, maybe things would have been worse without the Universal Declaration of Human Rights. Or maybe the Universal Declaration of Human Rights really wasn't in a situation to actually affect things like this. In many of the countries around the world, not just the orange ones, but often in many of the green ones as well, you continue to see things that go against those ideas of universal human rights. Even if the UN passes something, and if one country doesn't want to abide by it, what action can the other countries take? Economic action, maybe sanctions, maybe military action, and to what degree are people actually willing to do that?
Malibu, did you hear the video?
Yes, Professor. At least a part of it. I was struggling with the internet here.
So you did not hear the total. Did you hear at least some part of it?
Yes, at least some part of it, yes.
So it is audible to you.
Yes.
Let me see whether I could play this video. And could you see the video now?
Now, no.
Okay, now could you see the video? Okay, let me share it. Where it is gone. No, this not. Could you see it now, video? Yes? Could it?
Yes.
Okay.
First, let's talk about this idea of international law.
Are you hearing me?
International law isn't really law per se, but more a series of customs and international agreements and arrangements about how the global community should operate, more so than a truly enforceable law. At the end of the day, the global community operates under state sovereignty. While a state going against international law might see some repercussions in terms of possibly sanctions or just some finger wagging, at the end of the day, states can still, for the most part, do whatever they want. However, states are compelled to follow international law in order to maintain positive relations with the rest of the international community. In terms of human rights, depending on how you classify them, there are between 9 and 18 documents that make up the body of human rights law. And you can see a list of these just scrolling down right next to me here. These come in the form of treaties, conventions, and covenants that all have a very similar role, and the names are used interchangeably. What these do is create binding agreements between states. If a state that ratifies one of these and breaks it, they are seen as breaking international law. First, one of these treaties is drafted by the UN. After a treaty is drafted by the UN, individual states are encouraged to sign it. Signing it, however, doesn't quite yet make it binding. What signing it does is it compels the states to agree to the principles of the new forthcoming treaty. However, after a state signs it, they then have the option to ratify it. And once a state ratifies a treaty, it then binds the state to that treaty, and the state is then known as being a party to the treaty. Let's take a look at a few examples here. Two of the more important human rights treaties are the dual covenants that were signed in 1976. The first is the International Covenant on Civil and Political Rights. And the second is the International Covenant on Economic, Social, and Cultural Rights. What these aim to do is enshrine some of the ideas from the Declaration of Human Rights into binding international law. Because these covenants are binding, the ratification is a little bit more spotty, especially in the case of the United States. The United States traditionally has been very hesitant to ratify these human rights treaties, believing that it infringes on their sovereignty. One example of one of these major international human rights treaties that the US hasn't ratified is the International Covenant on Economic, Social, and Cultural Rights. And different American governments have believed that some of the elements in this covenant, especially in terms of things like healthcare, reproductive rights, and economic freedom, would infringe on some of the central core values of the United States. On the other hand, many do believe that ratification of a treaty like this could potentially go a long way in addressing some of the issues around poverty and inequality that the United States continues to face to this day. Another example is the Convention on the Rights of the Child, which came into effect in the year 1990. This one, for example, aims to provide compulsory elementary education to children and regulation around the age of employment, trying to make sure that child labor is eradicated from the world. In fact, in Canada, the 2003 Youth Criminal Justice Act that aimed to reform how criminal justice affects minors specifically referenced the Convention of the Rights of the Child as a guiding document in the formation of this new legislation in Canada. And so we see that while internationally sometimes being part of these documents doesn't lead to meaningful enforcement, often states do take being party to these treaties in order to improve or work on their own domestic legislation, like in the case of Canada and the Youth Criminal Justice Act. New declarations often start this process. In 2007, came into effect the United Nations Declaration on the Rights of Indigenous Persons. On the initial vote, 4 countries voted against this declaration. Those included Canada, the United States, Australia, and New Zealand. 4 countries that have a very troubled past with their Indigenous populations. And all 4 are currently undergoing processes to try and heal some of those divisions created by previous policies. While what might then follow are some more binding treaties without the participation of these 4 countries that have this troubled history with their Indigenous populations, it'll be difficult to form meaningful treaties that will be able to solve some of these issues. So at the end of the day, a major question around these human rights law documents is how effective are they really? Because again, in a world where state sovereignty rules supreme and enforcing these internationally is tremendously difficult, what role do they actually play in the international community? Some countries use ratification of these as ways to guide their policy, but again, the difficulty in enforcing these violations continues to be a major barrier in meaningful change on human rights globally. And with that, thank you for watching. Make sure to subscribe if you haven't already so you don't miss anything, and we'll see you again next time.
So did you hear it clearly? This video also.
Yes.
I appreciate. Then I say stop the thing. Because you joined later, what is the reason? Do you think that there is no class at all? Yes?
There is a problem of internet.
Problem with?
The internet issues.
How do you solve it? Tell me. There should be some mechanism should be there. At least read what I posted on the screen.
Okay. What are the 7 main international human rights? Human rights protected by the International Covenant on Civil and Political Rights, ICCPR, include the right to vote, the right to freedom of association, the right to a fair trial, right to privacy, and the right to freedom of religion. This is by Professor Mohammed Saheb Hussain.
Yes, because this thing which I made, and there are 3 important features of human rights. Read. Read.
I cannot see properly. Sorry.
You cannot see properly.
Yes, they are too small.
Too small. I can highlight it.
Yes.
So that you could see more. Control place. Oh, it is not actioning. Yeah, there are 3 important features of the human rights. Number 1, human rights are inalienable. They cannot be taken away from an individual or a group of individuals except in a specific situation according to the due process. For example, the right to liberty may have to be restricted if an individual is found to be guilty of a crime by a court of law. Number 2, only 5 minutes are left. Human rights are independent and indivisible. Without any having the means to exercise their civil and political right, people cannot assert their economic, social, and cultural rights. Similarly, without means of livelihood and a working society, people cannot access their civil and political rights. The fact has been confirmed by the Vienna Declaration and Program of Action at the World Conference on Human Rights in 1993. Number 3, human rights are equal and non-discriminatory. All human beings are equally entitled to them without any type of discrimination. It prohibits the discrimination on the basis of sex, race, religion, ethnicity, color, caste, community, and economic status. This is based on the principle that all human beings are born free and equal in dignity and rights. Is it clearly audible to you?
Yes.
How is my style of reading? Haraka?
Yeah. Haraka, but I can hear it.
And you can understand it also.
Exactly.
Yes. See, in this class, what exactly the international human rights law is. And that I dealt it, which is a test of yours is the first question. Sir, why did you do again? Because we wrote the test. It doesn't mean, but you are supposed to know what international human rights law are there. And what are the 7 rights it will be protected. And what is the treaty, declaration, and how it can play an important role. And why the people want to become a member of this a declaration, because every country want on this planet a peaceful, secured life. Healthy, peaceful, secured life. That is the manifestation of the United Nations. And if you happen to see the logo, it also says the same thing. I don't know whether you've seen the logo of UNO. Did you see the UNO logo? It is written the same thing. This is the UNO logo. And in the side, let me see that what are the wordings are given over there. Yeah, it's the logo, but side it is not clearly mentioned. But in some logos, no, it is clearly mentioned healthy, something like that, healthy planet, healthy society, healthy security, liberty, security, and yeah, these are the things on the planet. And the UN logo, we could see it. These are the different type of the logos are, I put it over there. And message, let me say, what is the message is giving with the logo? Here I could not see but there is a message is there, what the UNO wants. United Nations logos are there, and these are also United Nations logos, and UNA logo, it is expanded to, yeah. So a man wants liberty, a man wants security, and a man wants the healthy on the earth planet. So that is the aim of and aim, let us say the aim also, because at any time it can stop. At any time it can stop. So up to that extent, let me see that what exactly that UNO logo and the side it would be there. Yeah, it is not there in this one. But when you see the freedom and security and the health on this planet, that is the main motto. Here it is a UN history, the UNO logo may be there, it seems. Yeah, the United Nations history and aims, objectives, origin of the UN. Of course, they said about the origin of the UN. Of course, First World War over, Second World War over, then only this aims and objective of the UN to maintain the peace and security. See, the word I used, no? To maintain the peace and security throughout the world, all member nations must settle their international dispute in such a way that would not endanger and world peace and security. World peace and security.
Tanzania.